Good morning, everyone. Thank you very much for joining us today. My name is Doug Scott. I'm with the Great Plains Institute, and it's my pleasure to welcome you to this webinar on the Supreme Court decision of West Virginia versus EPA. Just to let you know, the webinar is being recorded, just want to make you aware of that. This West Virginia versus EPA, obviously a much anticipated decision, and has drawn a lot of reactions since it came out a couple of weeks ago. Came about after years-long litigation surrounding originally the EPA's Clean Power Plan and then later the Affordable Clean Energy Rule. Becomes very important as we believe EPA is working on new regulations to govern the power sector emissions. They've said that those regulations are expected in March, and obviously this decision will have a lot to do with how those regulations get formed. In addition, EPA is looking at emissions from industrial processes as the power sector continues to produce less greenhouse gas emissions. Expect additional work on other emission sectors, whether it's transportation or industry or buildings. The decision in West Virginia case is interesting because of the rationale used by the majority to invalidate parts of the Clean Power Plan. It'll be instructive to the agency going forward and also to other agencies who are also thinking about issuing regulations both inside the energy and environmental sphere and then outside of that as well. Our goal today is to provide the best take on the decision that we can, what it means for carbon regulations in the short term and also going forward. There have been lots of thoughts, lots of webinars, lots of opinion pieces that have been written about this. And what we're just trying to do is give you our best interpretation of the decision itself, the background for it, and what it means going forward. We're fortunate today to have some folks who are going to speak about this with you, and starting with a Clean Air Act expert who will lead our discussion today. Franz Litz of Litz Strategies and the Great Plains Institute, was a former air regulator in New York. Most of you know Franz and know that he is also, since he left New York, where he was instrumental in starting the regional greenhouse gas program there, the RGGI program. But he's also helped a number of other states on clean energy and clean air plans. Franz is going to present about the case, and then we're going to hear from two attorneys who participated in major ways in the litigation. We're going to hear from Jay Duffy of the Clean Air Task Force. Jay represented many of the interests of many different NGOs in the litigation. And then we'll also hear from Kevin Poloncarz of Covington and Burlington, who represented a lot of the industry who were supportive of EPA having the ability to regulate greenhouse gas emissions. And then we'll be glad after that to take your questions and comments. Franz will give a presentation first, and then we will hear from Jay and then from Kevin. You will also take time to answer your questions. There is a Q&A function where you can write questions in that will get to us, and we will feed those to Franz and to Jay and to Kevin. There's also a chat function if you want to put something in the chat. And then if you want to, if your question may be a little bit more complicated and not worthy of putting in the chat, or the Q&A section may be too difficult for that, feel free to use the raise your hand function, and then we will unmute you. And so you can ask your question as well. So we've got an hour. There's a lot to get to in an hour. And so again, thank you very much for being with us. And let me turn the program over to Franz Litz. Franz?
Hey, Doug, thanks so much for that introduction. Great to be with the stakeholders of the Carbon Capture Coalition, the Industrial Innovation Initiative, and also the Regional Deployment Initiative. So I think that means we have NGOs, we have companies, and we also have some state folks in the audience. So great to be with you all. I'm going to share my screen. Look at that, I did two things at once. How's that look, Grace?
Looks great, Franz.
Okay, great. So just a note to start here. I'm going to try to be as brief and as objective as possible in describing this decision. So I'm leaving out anything subjective or anything else I might include in a description of this case, and try to just give you the bare bones objective statements of the court and what we think it means. And I'm going to do that as quickly as possible so we can get to the meaty discussion. I'll start with the context. And by that, I mean the Clean Air Act context and the carbon regulation context. And then I'll turn to the case and quickly cover the background, what the decision says, and how the major question doctrine was used by the court in the decision, again, from as objectively as possible. And then turn to some observations of what it might mean for EPA and the states. And also, since this group is really focused on carbon capture and hydrogen, and industry, touch on what the decision might mean for carbon capture and for industry. And then, as Doug said, we're really, one of the great things about the coalition and the GPI stakeholder groups is that there's some groups, really just some terrific participants that know their stuff, and two of those are teed up to start Clean Air Task Force and Calpine. So without any more, let's dive in. So the context for this decision is Clean Air Act Section 111D, and it covers existing source categories and only those categories for which EPA has issued a new source performance standard. And so for the power sector, we're talking about combustion turbines and steam turbines, gas plants, coal plants, essentially. Those are the shorthands that are often used. And it also only applies for pollutants that are neither a NAAQS criteria pollutant nor a hazardous air pollutant. So greenhouse gases. The reason we're always focused on Section 111D is that that's where greenhouse gases find their way into regulation of existing sources. Under 111D, you have what is very common in the Clean Air Act, a federal and state interplay, a collaboration or cooperative federalism, however you want to describe it. And the way it works is EPA sets quote unquote guidelines. To lay people, that often sounds like they're not mandatory, but even though the Act uses the term guidelines, they are mandatory. And EPA sets the standard or the minimum emissions limitation that applies to the category of sources, and also prescribes requirements for state plans. And that includes things like when the state has to submit its plan and what has to be in that plan in order to be approved by EPA. And states develop and submit plans where they have to apply requirements to the category of sources that are designed to achieve the standard that EPA issued. And then if EPA is happy with the plan, they approve it. But if they're not, EPA has the ability to substitute the state plan with what is called as a federal implementation plan, a FIP. And there's a section in the Act that refers to states taking into account the remaining useful life. That's in the piece of what states does, and maybe we'll come back to that. That is a part of it. So states get the standard from the feds. They apply the requirements to sources to achieve the federal standard, and they take into account remaining useful life of the plants. So to the case. West Virginia is about a challenge to the Trump EPA's Affordable Clean Energy Rule and its simultaneous repeal of the Clean Power Plan. And the DC Circuit, when it heard the case, ruled against the Trump EPA and in favor of the underlying rationale of the Clean Power Plan. The Supreme Court, as you know, the top line is that it reversed that decision. And it did so without really focusing on the Affordable Clean Energy Rule at all, but rather focusing on the Clean Power Plan. Which means we have to just refresh our memories about what the Clean Power Plan was about. And how did EPA set the standard in that case, in that situation, for that rule? They had building blocks that they used to set the best system of emission reduction. They also had a long discussion on whether the standard should be mass versus rate, and ultimately they expressed the standard for each state in terms of rate, but also gave states a mass-based equivalent that they would have to meet through their plans. And they gave states lots of flexibility in their plans. They provided model trading rules, which they expressed as a potential federal implementation plan, but states were free to use it as a model trading rule if they liked, or to propose another approach to achieve the requirements. So what were the building blocks? This goes to the heart of what the Supreme Court was focused on. There were three building blocks in setting the emissions reduction that EPA was requiring of states under the Clean Power Plan. They determined the best system of emission reductions was a combination of heat rate improvements at the power plants, a shift from coal to gas generation, and a shift from fossil plants to renewable energy generation. That's where the generation shifting came in building blocks 2 and 3. And it's what the court focused on. And as I mentioned, each state got a rate-based requirement, and then they also got a mass-based equivalent if they chose to approach it that way. And EPA came up with model cap and trade rules, both a rate-based version and a mass-based version that states could use, and set timelines for submission of the state plan. In the Supreme Court case, EPA essentially said building blocks 2 and 3 were not within EPA's authority. EPA could not set the standard using generation shifting. And the court noted that EPA has always based the standard on plants operation, add-on technology, or fuel switching. But it expressly did not conclude that all the measures have to be inside the fence line, which I think could be important in our discussions around how carbon capture comes to play. The court applied the major question doctrine in kind of, as I say, a bare bones outline of how they did that. They started by saying, section 111D is a little used section. It's kind of a gap filler. As I pointed out originally, it only applies to pollutants that are not criteria pollutants or toxic pollutants. And that's where greenhouse gases fit. They looked at prior instances of how EPA used the 111D section and noted that they had always relied on anti-plant measures until the CPP. And they said or accused, or they said EPA sought to control the makeup of, I guess accused is not a very objective word, is it? EPA sought to change the makeup of the power sector directly. And when they said they wanted to have coal plants shift to gas and coal and gas shift to renewables, and that's such a major question that Congress wouldn't have asked EPA to answer that question without a clear expression in the statute, which they found did not exist. And so EPA did not have the authority to use generation shifting in setting the standard. So one way to think about this is to reflect on the questions that we had before the decision came out. A lot of us were wondering whether EPA would be limited to inside the fence line measures when setting the standard. The court expressly declined to say they were limited to inside the fence line measures, but noted that that was how EPA had implemented the standard in the past. So we might think of that as, well, inside the fence line measures are the safest and more traditional approach that the court has sort of already said is okay. But then the question, the gray area is, since they didn't say outside the fence line measures are prohibited, what might be allowed? Another question we had was, if EPA is limited in that way, what kind of stringency might we expect? Are there technologies that can meet the standards and cost thresholds that will allow for some stringency in the federal standard? Does the standard have to be rate or mass? Does it matter? What might the role be of fuel switching? These are things we asked. And will states have broad flexibility in their plans? And the court talks about the reduction in mass terms in the decision. There may not be full agreement that indicates the court is okay with EPA taking a mass-based approach, but it's worth noting that they did talk about it in terms of mass. And on fuel switching, they did talk about fuel switching as being part of the traditional approach, but they noted in a footnote that EPA probably couldn't require a coal plant to switch 100% to gas. So there's still this question of how much fuel switching would be allowed. And then lastly, they don't do anything to limit the broad flexibility that states have under the statute. And so I would say that the states proposing trading programs like RGGI are probably okay based on the other discussions that were in the decision. For EPA, what does it mean? We know from talking to EPA, as I'm sure many of you did, they were sort of headed in an inside the fence line direction already, so the decision doesn't really change their course much. And in fact, the decision offers some clarity about what the court might frown upon, like that 100% fuel switching question. That seems pretty clear in footnote 3 of the decision. They won't like that. And there are other things that make things clearer for EPA. And then what is the basis of the standard? They've already been looking at the technologies that could be applied at the plant and the fuels that might be used, as well as heat rate improvements. For states, the court confirms the state's role in applying the requirements to the sources. And in an interesting discussion of the Clean Air Mercury rule, which never came before the court, the Supreme Court, the court did suggest that EPA could have offered up trading to the states, but not as a method of setting stringency. So that implies no generation shifting, no cap and trade to figure out how much the stringency is. But once you set the stringency through the acceptable method, you can allow states to be flexible in the way they get the reductions. And then where does that leave carbon capture? Well, EPA has the natural gas technology white paper out there, as we've talked about in the coalition, in the regulatory subgroup. And as Doug mentioned, the proposals are due to come out in March, and that means the existing source guidelines that were the subject of the West Virginia case that will cover gas and coal, or one or the other, we're not sure exactly yet, and that the new source performance standard will be out then too, and it's going to at least cover gas. They're at least revisiting the gas standard. And since add-on technology is squarely in that traditional mode of regulation for EPA and fuels switching as well, both carbon capture and carbon capture as a way to decarbonize hydrogen production seem to be squarely in the realm of what EPA can consider when setting these standards. I do want to note one thing, is that just because if EPA were to base the standard on some CCUS and some hydrogen, it doesn't necessarily mean that we'll see projects because of the EPA standard. Indeed, the standards get expressed in terms of emissions rate, emissions reductions, and then the sources just have to meet the standard. And the cost may lead to fewer or no new plants. Like, let's say there was a new gas standard that required CCS, and we didn't get the tax credits that the coalition is pushing for from Congress. Maybe we would see that as a barrier to new gas. And then with the existing plant rules, important to remember that EPA sets the standard, but the states decide how the standard is met. So EPA could serve up a standard based on carbon capture and hydrogen or some combination thereof, and states would then be free to achieve that standard flexibly. So there's this, important to remember, this two-stage approach to those existing standards. And then lastly, because we have the Industrial Innovation Initiative partners here, wanted to note the Clean Air Act, Section 111B and Section 111D, because it sort of picks up the slack where the greenhouse gases are not covered by the criteria provisions or by the toxic provisions, they have been thought of as how industrial source categories will be covered. And so I think it's an interesting question to consider, given the court's decision. How do we think that decision affects that ability of EPA to use 111B and 111D for industrial source categories at all? And the two reports on top here are two reports I was a co-author of at WRI in 2010 and 2013. And we did as part of that a survey of lawyers, Clean Air Act lawyers, to determine how they thought about those provisions. And in general, it was thought of that 111B and 111D would be the way that EPA ultimately could use the Clean Air Act to get reductions from industrial sources. So the question is, how does West Virginia affect that at all? And I'll just say very briefly and end that I think the analysis might go something like, well, EPA hasn't covered them in the past. And so, it's not really, it's arguably, the argument will go for people who don't want it, that it's a major question, and maybe it's too major a question to assume EPA could now start regulating industry under 111D. But I've heard both sides already from lawyers out there. So I don't think that that question is anywhere near settled at this point. And I will stop there. And then I think, Doug, back to you and
Yeah,
to
thanks.
our keyed up respondents.
Thanks, Franz. And yeah, let me turn first to Jay and then to Kevin, and maybe do a couple things for us, if you would. First of all, push back on anything that Franz said. If you've got a different thought on that, that's what this is for. It's to get those thoughts out there, and you were intimately involved, both of you, with this litigation. So the other thing would be, if there are anything in this decision that was surprising to you, or thoughts that you've got on how you think this will play out in future discussions as well, in future litigation as well, especially maybe the major questions doctrine, because I know that's such an integral part of this. So let me turn first to Jay, and of course you could talk about anything else you'd like to as well, Jay. So we just really appreciate you being on, and please take it away, and then we'll hear from Kevin, and then we'll turn to the audience and take a lot of questions. So Jay, go ahead.
Sounds good. Thanks so much for having me, Jay Duffy. I am an attorney with the Clean Air Task Force and represented a number of public health and environmental organizations throughout the West Virginia Clean Power Plan, all the rest of the long tortured history we've been through as far as trying to determine what the best system of emission reduction is. And as Franz said, kind of the only thing that was taken off the plate here was the clean power plant system, the sort of generation shifting. The court, leaves the door open for systems that cause the regulated source to operate more cleanly. This includes efficiency improvements, fuel switching, and add-on control. So the things I've been thinking about, we have been thinking about CCS as a basis for these rules since the outset here at CATF. Even when the Clean Power Plan was proposed, we submitted a set of comments that said, here's an alternate method by which you can reach the same emission limits, including these sort of inside the fence, reduced generation, CCS, co-firing, efficiency measures. So we've been thinking in this lane for quite some time, and it appears that this is the safest lane. I think I agree that there aren't things that are explicitly taken off the table, but there are safer methods. And the couple things I've been thinking about lately are where CCS has already been opined upon by EPA. It was very glaringly missing from any discussion in the majority's opinion in West Virginia. And I think that's for good reason, because it really is that same sort of bolt-on inside the source carbon scrubber that pollution controls have been the same sort of pollution controls that have been used for decades. So, in 2015, when EPA finalized the Clean Power Plan, they first did look at inside the fence measures. They looked at CCS. They looked at co-firing, and they decided that those things met all of the criteria of the Clean Air Act. But even though those methods met the Clean Air criteria, EPA was bombarded with evidence that the industry preferred this sort of generation shifting method, and that, as Franz kind of mentioned, that the emission limit doesn't need to be complied with through the system that it's based upon. The power plants have authority and flexibility to meet those emission limits however they see fit. So EPA said, even if we set a standard based on CCS or co-firing, we think the power sector is going to comply through generation shifting. So let's cut to the chase. But that's off the table now. So we do have this decision under the Clean Power Plan where EPA did previously say that CCS was an adequately demonstrated cost reasonable approach. And then also, we have this currently, if a new coal-fired power plant is built, the standard is based on partial carbon capture. And there they did find that it was adequately demonstrated cost reasonable, all the hallmarks of a valid Clean Air Act system of emission reduction. That case will be really interesting to watch. That finding and that final rule for coal-fired power plants was challenged by red states, coal and some power interests in the DC Circuit in a case called North Dakota versus EPA. We fully briefed that case, and we had oral arguments set, and then the oral argument was canceled because the Trump administration proposed to repeal the standard. It never finalized that proposal, and now that proposal is just kind of hanging out there. And the Biden administration is considering what to do. So I represent several clients in that case, and I'll be really interested to see, what the court does with a CCS-based standard. Just two things that I want to highlight that Franz kind of did in his presentation, but I think it is really helpful to keep in mind as we start thinking about what a CCS-based 111 standard might mean. And first, it's that a technology need not be on every street corner to form a basis, a part of the basis for emission standards. A lot of power plants, don't control their carbon because there's no regulations. Some do, and Kevin will talk about that. But controlling emissions costs money, and when it's permissible to kind of release them into the atmosphere for free, it's a no-brainer. That's why we need regulations. So the courts and the Clean Air Act have recognized that the Clean Air Act is a technology forcing and a forward-looking statute, and that it kind of needs to pull industry. And so the record for CCS is really robust as compared to some other systems that have been the basis of standards. And I feel like the record gets stronger every day, and the work that this group does is important to that effort as well. The other point I just wanted to make, which Franz did as well, which is a standard based on CCS is not a mandate to install CCS. So I've seen in the press already that EPA may be mandating CCS. And that is not the case. There will be a choice for plants if they can meet an emission limit based on CCS and keep operating. That's great. If they decide to meet it in some other way, that's also fine. If they decide that it doesn't work for that individual plant due to its economic situation, then that's also fine. But it's gone on for too long that there's the option to do nothing to control carbon emissions. So I think the CCS option as the basis of standards is the right path forward. And with that, I will pass it over to my friend Kevin or Scott or Doug.
Thanks so much, Jay, and Kevin. As you start your remarks, Jay's rocking the Villanova pennant behind him. I'm a Marquette guy, so feel free to shout out any Big East school you want to during the course of this. So
I gotta
Kevin,
give my cat. I said I gotta give my Catamounts a shout too. They keep getting blocked by my
That's
dome.
Right. Go Vermont. All right, Kevin. Thank you very much for being here, and please feel free to make your remarks. Kevin, go ahead. Yep, you're muted, I think, Kevin.
There you go. It's just unmuted me. Well, thanks for having me, and I'm really happy to be here. And just to clarify, what my role is and who I'm here on behalf of. I, like Jay, have been involved in this very long series of litigations. I argued on behalf of 10 power companies, the main statutory point upon which the DC Circuit vacated the repeal of the Clean Power Plan and the DC Circuit, and then participated in the Supreme Court briefing, and my partner Beth Brinkman argued the case alongside the Solicitor General. But I'm actually here today at the request of Calpine, who is a client of mine, not one of the parties in this case, but is one of the parties still who defended the CCS-based standard for coal plants in the North Dakota case that Jay just mentioned. And Calpine has been a longtime supporter of carbon regulation, including as a defender of the Clean Power Plan. And I was asked just to speak briefly upon what the decision means with respect to CCS as a possible basis for a standard. And I won't go into detail that Jay already went through, because I think it's fairly clear that bolt-on technology, that very traditional technology, can serve as the basis of a best system of emission reduction. And then we will instead be defending whether it is adequately demonstrated, whether it is technically feasible, whether it is cost effective. All those things will come into play in what we imagine would be a fairly traditional type of analysis by EPA and analysis by any reviewing court, not subject to the type of major questions doctrine that the court applied in essentially striking down the Clean Power Plan. I do think, and I agree with Jay, that the court's ruling, there's been a lot of hand wringing about the court's ruling, but in fact, the court's ruling was about as narrow as it could have been with respect to the scope of EPA's authority and what they were taking off the table. All they took off the table was generation shifting. And while the Trump administration had this view that the best system could be limited to nothing more than what you could do at an individual plant, taking off the table trading and everything like that, the court did not endorse that, as Franz made clear. And so there's a lot of room for creativity. And I do think that the court's discussion of the Clean Air Mercury Rule is really key and critical to our understanding of what might be possible for EPA in setting a standard and then providing compliance flexibility. We argued that the Clean Air Mercury Rule was very similar to what the Clean Power Plan did. It was a cap and trade program set by the Bush administration for mercury emissions, never went into effect because it was struck down for other reasons. And in an oral argument, Justice Kavanaugh said, you really leaned into this Clean Air Mercury Rule argument. We said, yes, because this was very, this is what EPA did. They basically said there's technology out there that can be used. And they said, not every source is going to have the ability to use this technology, but because we're establishing a trading option, it doesn't matter that not every source may have the ability to implement this technology in the near term. And they also set future year budgets more stringently, saying we prognosticate at EPA that in the future, this technology is going to become more widely available and adequately demonstrated. And so sitting where we are today, we're going to set some more modest budgets in the near term, but in the future, when we think that this technology will be more available, the budgets will be more stringent. And because of the flexibility afforded to trade by trading, we don't need to worry that not every single source can implement that technology. And I think that that's a really critical thing for us to think about in how EPA might develop a CCS-based standard for plants, and then provide flexibility so that this doesn't, as Jay said, amount to a quote unquote CCS mandate. And so Jay, Franz, and I, and others who have been involved in this are going to continue to tease out what this means and what we think is possible and most defensible, because obviously this court has indicated this was a real shot over the bow from purposes of administrative law. It's truly a seismic shift, this major questions doctrine. They've indicated that they're going to look with a lot of scrutiny when EPA is trying to tread ground that it hasn't tread before, or any agency for that matter. So I think that that's where I'll leave it. And I just really appreciate the opportunity to be here today. Jay has been a wonderful partner through all this litigation. We've been on the same side. We participated in that 9-hour oral argument together, and it was quite a battle. So thanks.
No, that's terrific, Jay and Kevin. Thanks very much. Stay on camera, because if you feel like jumping in on a question as they come up, feel free to do that. We'd appreciate your thoughts. We've got a couple questions that have come up in the Q&A. Remember, you can do that, ask your questions through the Q&A or in the chat, or if you want to use the raise your hand function, we will unmute you and call on you. So there's a couple questions here that relate to criteria pollutants, not necessarily to greenhouse gases, but so the first one, Franz, and then again, Jay, Kevin, if you'd like to opine on this, feel free. But the question was about the impact on the ozone transport rule, the good neighbor rule. Do you see anything in this decision? I know this has come up in a lot of places as well, because EPA's got a suite of other rules that they've been working on and issuing, and will issue more. Anything in this decision that you see that would impact that rule?
I don't think so. And let me just say why. To the extent that EPA is doing something that it's done time and time again, and it's sort of in the bread and, in the bread basket, sort of bread and butter approach to reducing pollution, they're on the safer end of the spectrum. It's when, at least under the major questions doctrine. So that's what I'm referring to. Does the West Virginia case have, raised questions about it? I won't, I'm not speaking generally. So major questions, the question would be, is EPA doing anything, is it acting in an area that's not something EPA would normally be expected to act in? Are they interpreting the statute in a weird way or overly creative way, or a way that's inconsistent with the way it's been done in the past? These kinds of inquiries help you think through whether you're going to run afoul of that doctrine. And I think the answer is no with respect to the good neighbor rule, or the good neighbor proposal that's out there.
Jay, go ahead.
Yeah, I just wanted to add one thing, a helpful flag for folks who are in the advocacy business, is there were a number of press releases and testimony and a lot of kind of hyperbolic press statements that were cited in the Supreme Court opinion. And I think messaging is very, very important to this court. Unfortunately, it should be confined, in my opinion, to the Federal Register and the record and what have you, and legal doctrine. But we saw a lot of pulling in, that EPA was trying to do this takeover of the electric grid, et cetera. And so, the question from the anonymous question there that kind of asks, is there a way to kind of through a back door, regulate carbon via other methods? I think that's problematic. I think this court needs to understand, and EPA needs to understand that we are focusing on each individual type of authority that EPA has under these different sections of the Act, and only regulating per that job, per that congressional assignment in that section of the Act. So whether it's reducing criteria pollutants or carbon or mercury or what have you, the focus needs to be there. Of course, they'll discuss, and they have to discuss the co-benefits, and that's relevant. But I would not recommend either using it as a tool or discussing it as a tool to kind of get around the Clean Air Act to do something else. The court was very focused on the intent of the agency, and whether the intent was to change the electric grid versus control carbon pollution from the individual sources.
There's a related question in the chat, and any of you are free to comment on this, but asking why why making a distinction between generation shifting and fuel switching, since it sounds like the latter is clearly within the authority of EPA, but the former is perhaps not. Is it the scale, or what differentiates between, as we talked about, setting a standard to say, this is the standard you've got to meet, and you don't have to have this technology, you can meet this in a variety of ways? What's the difference between that and what the court is saying EPA did in this case? It's probably a good distinction to reinforce. Anybody?
Well, that's been something, I'll jump in. That's been something we've been litigating essentially for several years. EPA took the position that, well, if we set the standard in one way and sources are going to comply by shifting generation, then why can't we set the standard that way? Well, we've learned that from this court, that is not a tenable way for EPA to proceed. But what the court did say, which is important, is that generation shifting that occurs incidentally as a result of a way the standard is set is acceptable. So if you set a standard, because any standard, we made this point, any standard you set for the power sector is going to change the dispatch of sources and cause the dispatch of cleaner sources. And so regardless whether it's a traditional bolt-on technology, that cost is going to be inflected through the power market by causing more clean generation to be dispatched more frequently. And so why do we need to make that distinction? The court drew the distinction and said, we said there was no textual basis for it. And they said, no, We think incidental generation shifting is okay, but as Jay made the point, the problem with the Clean Power Plan and the decision is suffused with these statements. Gina McCarthy said, this isn't about pollution control at all. This is about changing the way we generate electricity throughout the US. That's not a good talking point. And us lawyers who are in the trenches defending have typically tried to plug our ears and be the politicals are going to say what they're going to say. They're going to chest pound. They're going to say this is the most monumental thing. And we're going to try to defend it based on the record. We've learned our lesson that you can't do that. And this court will let all of those statements about what the intent was of the rule to come into play when we actually try